CrPC Chapter 32 Execution, Suspension, Remission and Commutation of Sentences. 8 Death Sentences. 413 Execution of Order passed under Section 368 when in a case submitted to the High Court for the confirmation of a sentence of death, the Court of Session receives the order of confirmation or other order of the High Court thereon. It shall cause such order to be carried into effect by issuing a warrant or taking such other step as may be necessary. 412 Execution of sentence of death passed by High Court. When a sentence of death is passed by High Court in appeal or in revision, the Court of Session shall, on receiving the order of the High Court, cause the sentence to be carried into effect by issuing a warrant. 415 Postponement of execution of sentence of death in a case of appeal to the Supreme Court, where a person is sentenced to the death by the High Court and an appeal from its judgment lies to the Supreme Court under subclause A or subclause B of Article 134 of the Constitution, the High Court shall order execution of sentence to postpone until the period allowed for the performing such appeal has expired, or if an appeal is preferred, within that period until such appeal is disposed of. Where a sentence of death is passed or conferred by the High Court and the person sentenced make an application to the High Court for the grant of certificate under Article 132 or under subclause C, clause 1 of Article 134, the High Court shall order the execution of sentence to be postponed until such application is disposed of by the High Court, or if a certificate is granted on such application until the period allowed for the preferring appeal to the Supreme Court on such certificate expire. Where a sentence of death is passed or conferred by the High Court and the High Court is satisfied that the person sentenced intends to present a petition to the Supreme Court for grant of special leave petition to under Article 136, the High Court shall order the execution of sentence to be postponed for such period as it considered sufficient to enable him to present such petition. 416 Postponement of capital punishment on pregnant woman. If a woman sentenced to the death is found to be pregnant, the High Court shall commute the sentence to the imprisonment for life. Part B Imprisonment. 417 Power to appoint place of imprisonment. Except when otherwise provided by any law for the time being in force, the state government may direct in what place any person liable to imprisoned or committed to the custody under this code shall be confined. If any person liable to imprison or committed to custody under this code is in confinement in a civil jail, the court or magistrate ordering the imprisonment or committal may direct that the person be removed to a criminal jail. When a person is removed to a criminal jail under subsection 2, he shall, on being released therefrom, be sent back to the civil jail unless either 3 years have been elapsed since he was removed to the criminal jail, in which a case he shall be deemed to have released from the civil jail under section 58 of the Civil Procedure 1908 or 23 of the Provincial Insolvency Act, as the case may be. B. The court which ordered his imprisonment in civil jail has certified to the officer in charge of criminal jail that he is entitled to be released under section 58 of CPC 1908 and under section 23 of Provincial Insolvency Act. तो 417 के क्लॉज 3 में ये दिया गया है कि कब रिलीज़ किया जाएगा किसी भी पर्सन को फ्रॉम द क्रिमिनल जेल, तो दो कंडीशन दी गई है. 418 है execution of sentence of imprisonment where the accused is sentenced to the imprisonment for life or to imprisonment for a term in the case other than those provided by section 413. The court passing the sentence shall forthwith forward a warrant to the jail or other place in which he is or is to be confined, and unless the accused is already confined in such jail or other place, shall forward him to such jail or other place with the warrant, provided that where the accused is sentenced to the imprisonment till the rising of the court, it shall not be necessary to prepare or forward a warrant to a jail, and the accused may confined in such place as the court may direct. 418 Clause 2. Where the accused is not present in the court, he is sentenced to such imprisonment as is mentioned in subsection 1. Court shall issue a warrant for his arrest for the purpose of forwarding him to the jail or other place in which he is to be confined, and in such case the sentence shall commence on the date of his arrest. 419 Direction of warrant for execution. Every warrant for execution of a sentence of imprisonment shall be directed to the officer in charge of jail or other place in which the prisoner is or is to be confined. 420 Warrant with whom to be lodged. When the prisoner is to be confined in a jail, the warrant shall be lodged with the jailer. 420 था C है, part C है levy of fine. 421 Warrant for levy of fine. Warrant for levy of fine. When an offender has sentenced to pay the fine, the court passing the sentence may take action for recovery of fine in either or both of the following ways, and that is to say it may issue a warrant for levy of the amount by attachment and sale of any movable property belonging to the offender. B. Issue a warrant to the collector of the district authorizing him to realize the amounts as arrear of land revenue from the movable or immovable property or both the defaulter, provided that if the sentence directs that in default of the payment of the fine the offender shall imprison, and if such offender has undergone the whole of such imprisonment in default, no court shall issue such warrant unless for the special reasons to be recorded in writing, and it considers it necessary so to do, or unless it has been made order for the payment of expenses or compensation out of one section 357. The state government may make rules regulating the manner in which the warrant under clause A of subsection 1 are to be executed, and for the summary determination of any claims made by any person other than the offender in respect of any property attached in execution of such warrant. Third, where the court issues a warrant to the collector under clause B of subsection 1, the collector shall realize the amount in accordance with the law relating to recovery of arrears of land revenue as if such warrant were certificate issued under such law, provided that no such warrant shall be executed by the arrest or detention in the prison of offender. Effect of such warrant. A warrant issued under clause A of subsection 1 of section 421 by any court may be executed with the local jurisdiction of such court, and it shall authorize the attachment and sale of any such property outside such jurisdiction when it is endorsed by the district magistrate within whose local jurisdiction such property is found. Warrant for levy of fine. 423 Warrant for levy of fine instead issued by a court in any territory to which the court does not extend, notwithstanding anything contained in this code or any other law for the time in force, when an offender has been sentenced to pay the fine a criminal court in a territory to which this court does not extend, and the court passing the sentence issues a warrant to the collector of a district in the territory to the which this code extends, authorizing him to realize the amount as if it were an area of land revenue. Such warrant shall be deemed to be a warrant issued under Clause B of subsection 1 of Section 421 by a court in the territory to which this court extends, and the provision of subsection 3 of said section as execution of such warrant shall apply accordingly.